A ruling from an Oklahoma County judge in an open records case involving emails from the governor's office appears headed to a higher court. The governor's office expects an appeal, and the ACLU, representing the Lost Ogle website, makes clear they intend to file one. At issue is whether Oklahoma's governor has a privilege to keep records secret.
The governor's office released 51,000 pages of documents to the news media following a more than 3-month-long wait for emails that involved her decision not to expand Medicaid under the Affordable Care Act. But left out was 31 other emails that the governor's counsel said she did not have to reveal. Ryan Kiesel is executive director of the Oklahoma ACLU.
The executive branch went in asserting 3 privileges.
Those were executive privilege, attorney-client privilege, and an exemption for deliberative process. The satirical website, The Lost Ogle, went to the ACLU and filed suit, arguing the governor did not have the authority to keep those 31 emails secret. Oklahoma County District Judge Barbara Swinton has ruled one of those exemptions does in fact apply. Judge Swinton held that the deliberative process privilege is recognized under common law in Oklahoma, and it is supported by Supreme Court rule as an exemption to the Oklahoma Open Records Act. The ACLU's Ryan Kiesel says the decision, at least, focuses their upcoming appeal.
And the judge only considering one. So I think that as far as narrowing down the issues that subsequent courts would have to consider, this order certainly does that.
The governor sees the ruling differently. In a statement from her communications director, Alex Wentz, that privilege is commonly exerted by chief executives on both state and federal levels to protect the ability to receive candid private advice on issues of public policy. In a posting on their website, the Lost Ogle responded, "Although we didn't win the case, we didn't necessarily lose it either. And that's because the judge agreed with us that Mary Fallon does not have the executive privilege to withhold the emails. That's important." The ACLU's Kiesel agrees that the finding was an important part of the case.
Which, as important as the governor of Oklahoma is certainly not to the level of privilege that the Chief Executive of the United States, Commander-in-Chief of the United States, is afforded.
Kiesel also asserts that the governor's power to use the deliberative process privilege is limited.
The governor is no longer going to unilaterally be able to call a document privileged under deliberative process and then not ever turn it over to the public. That assertion of deliberative process has to be tested by the court.
The test in this case is another part of the judge's ruling. The defendant is ordered to produce a privilege log of the 100 documents at issue. While the judge said the content of the emails may be withheld, the privilege log must include dates, sender, recipients, and reference lines included. And while that information will help understand who was lobbying the governor's office, Kiesel says it falls short of real openness in government.
What the people of Oklahoma are entitled to is the full content of these records. And as this litigation goes on, I think that we still are very confident that that's what will happen.
The statement from spokesman Alex Wentz shows the governor believes that she has been truly transparent and open. We have to date released over 100,000 pages of documents in response to open records requests, more than all other Oklahoma governors combined. We will continue to release our records and maintain our commitment to open government. The statement also recognized that the decision is not the end of the issue. We expect today's ruling to be just the first step in a longer legal process. The judge's decision is based on common law, something that is superseded by statute and the Constitution, and which will be at the root of an appeal. Kiesel says if lawmakers really wanted Oklahoma's governor to have that kind of power, they could have already done it.
If the executive branch or the legislature want to create a deliberative process exemption, there's a way for them to do that very easily. The problem is that I don't think that the people of Oklahoma would go for it.
The Lost Ogle and the ACLU believe the unreleased emails go to the heart of the decision-making process.
Both under our Constitution and under the Open Records Act, the people of Oklahoma are afforded a front row seat, if they want to take it, to how their government is being operated and how decision makers are making the decisions that impact their lives in big ways and small. And that's what this case is fundamentally about.
Judge Swinton gave the governor 20 days to turn over the logs of those 31 emails.
The Oklahoma Attorney General has issued a legal opinion that says the legislature violated the state constitution in drafting the fiscal year 2015 state budget. The opinion was sought by a Democratic state representative who says the decision raises a host of questions on what happens next if the state budget is out of balance.
Attorney General Scott Pruitt's opinion determined that the legislature's order to the State Equalization Board to take $7.9 million from the Oklahoma's Promise Trust Fund for use elsewhere in the budget was unconstitutional on at least 3 different counts. The opinion found that because Senate Bill 2127 is a general appropriations bill, it can contain only appropriations and cannot contain any substantive law, which it currently does. That if the law was a special appropriations bill, it would still be unconstitutional because it fails to comply with the single subject rule. And under the Constitution, the legislature lacks the authority to direct the State Board of Equalization on how to calculate the amount to be certified as available for appropriation. In other words, they lack the authority to do what they did. House Minority Leader Representative Scott Inman asked for the legal opinion and says the next move appears to be up to the State Equalization Board, which is chaired by the governor.
We hope now that the Board of Equalization will do what's within their constitutional authority and stand up and ignore the legislative's illegal and immoral edict to rob $8 million from Oklahoma's Promise.
Representative Inman says he is confident the Equalization Board will follow the Attorney General's opinion because to do otherwise would put the new state budget in court.
Because anything else would require would trigger the Regents for Higher Education to sue the state and require that money be placed back in there.
Representative Mike Reynolds has already said he expects a lawsuit to be filed challenging various provisions of the new state budget as unconstitutional. Representative Inman says he thinks there are other violations as well.
We're currently combing through the budget. We've discussed some of the budgetary shortfalls thanks to robbing of other revolving funds. We're not ready to come out and make a complete statement yet on some of these issues, but we think that there may be further announcements or further requests for Attorney General's opinions in the future.
Regardless of whether another legal challenge is forthcoming on the budget, the Attorney General's opinion leaves numerous questions unanswered. The State Equalization Board has to certify the final funds for the new budget before July 1st, but the ruling leaves the budget unbalanced, which also violates the Constitution. To get the budget in balance, apparently some state agency will have to take another financial hit.
One particular provision may kick into effect, which would require the last $7.8 million or roughly $8 million that was expended within the budget, that money basically would be done away with. And we're not exactly sure what that looks like. That may mean workers' comp courts. I'm not sure who would be the negative recipient of this particular opinion.
The governor's spokesman, Alex Wentz, says their legal staff is reviewing the legal and fiscal implications of the opinion. And the governor has rescheduled the Equalization Board's meeting for June 26th, following meetings with legislative leaders on what the board should do. John Estes, spokesman for Finance Secretary Preston Dorflinger, says several options are being discussed. The only one that has been made public is to take the nearly $8 million out of the higher education budget and give it back to them next year as a supplemental appropriation. But Estes says no special session will be necessary to put the state budget back in balance.